We've had some wonderful speakers today. We're going to continue with a legal panel. And as the attorneys who've been asked to present make their way to the podium or to the stage, let me tell you who we have here today. You know Doug McSwain. You've seen him earlier. He's going to pretty much be the moderator of this. He is an attorney with one of our prominent firms here in the Tyler-Smith County area. And that is the Potter firm. Our county judge, Nathaniel Moran, county was a city council member when I was mayor. Phenomenal guy. The mental health, the involuntary commitment comes through the county government in the state of Texas. So as the county judge, that goes through his office. We have Deputy David Biggs. David is the Crisis Intervention Team Officer, the CIT. Someone asked a question about that. I think there'll be probably a little bit of addressing it in the process. We have Richard Pattison. Richard is also an attorney here. He is the county representative for involuntary commitment. All of that is in conjunction with the DA's office, and we have Thomas Wilson, who is assistant district attorney. And then we have Ron back up here. Oh, Ron's not here. Okay. And Ron here is with NAMI. You heard him earlier. He referenced his website. There is information. There was a question about Medicare and accessing it. If you go to the NAMI website, I think you can help get some answers there, or you can send questions and they will respond and get you some answers. So that was a wonderful resource, and he discussed a lot of the resources there. So with our theme today on youth, young adults, on the involuntary commitment and all of the legal issues, Doug, take it away.
Yes, ma'am. Okay, let me get a little organized here. But let me tell you what, the most common questions I get all the time, sometimes 3 or 4 times a week, is my child is manifesting signs of mental illness. What do I do? How do I go about getting them help and treatment? And tell me about what the law is on involuntary commitments. Tell me what to do. That's one of the reasons why we organize this legal panel, because we're going to take you overall through the system. Judge Moran's going to do that, and then I'm going to take you through the process. I'm going to go to Deputy Biggs, who's generally the first ones on scene. I'm going to take it to Thomas Wilson, and then Richard, and so we'll get started on it. But I'm hopeful that we can answer a lot of questions, and let's start with Judge Moran. Judge, can you describe the system for us?
Absolutely. Good afternoon to everybody. I'm going to put up a couple slides up on the screen. Oh, good, there's one. I hope that you can see this. We wanted to provide a little bit of an overview, like a 20,000-foot view of what the system looks like when you're looking from above. It is a system that is imperfect, as all of you know. It's a system that needs some changes, and it's a system that cannot adapt to every need. So let me just say that up front. The legal system cannot do everything that we need it to do to help those that are in mental health stresses in our society. But our job is, and the job of every one of the individuals up here, is to follow the law. Now that is one of the frustrating things that you sitting out there that are experiencing situations, and us that are involved in making the decisions, we're all confronted with. We're constrained by what does the law allow us to do. So let me take you through a typical scenario of involuntary commitment through the screen, and then we're going to talk about the players that are involved, and they're all sitting up here, and most of them all are. Typically, in an involuntary commitment, and this is on the civil side, so separate the civil from the criminal. If it's on the criminal side, those commitments typically are going to go through whatever court has that criminal case. So on the civil side, my job as the county judge here in Smith County is to handle those situations that are brought before me where there's typically not a criminal charge. In a few instances where it's a nonviolent case, they may have a criminal charge, but that is the rare exception. So let's begin at the beginning of the process. How does it typically start? Well, it typically starts with A family member or a friend who observes somebody that needs some help. They're in a distress situation. They call the police. Officer Biggs is out there. They call the sheriff's office. Or they take somebody to the hospital, to the emergency room. That's typically how the process is going to start. Legally, how does it start the process so that it can get to my court, so that I can make a decision whether or not to involuntarily commit somebody for help or not? Well, it starts in two ways. Either an emergency distress warrant that's signed by me, that's presented to me for signature, which lasts for up to 48 hours, or a peace officer's warrant, which is signed on the spot by somebody like Officer Biggs. Let me tell you the little bit of a differences between those two. And one of the things I want you to realize as we go through this process is you're going to realize as you move further down the process, what you see on the screen is somebody can be detained for a little bit longer amount of period of time. So what the law does is the law wants to step in there and say, okay, if we're going to allow for a person to be detained against their will for a longer period of time, we're going to increase the burden of proof on you. We're going to increase the amount of testimony that you're going to need, and we're going to make it a little bit more difficult. We're going to give more rights as we get down the line. So what we see at the front end of a 48-hour detention is a whole lot less of a standard or a burden than what we're going to see at the very end with a 1-year commitment. It's much tougher when you get to that point in the process. So say Officer Biggs shows up at the scene and he understands that somebody is in need of emergency detention because they're substantial risk of serious harm to themselves or others. That's a term you're going to hear more and more as we go through this process. If he observes that and he determines that he does not have time to bring that before my court for an emergency detention warrant, he can issue that peace officer's warrant on the spot. Now, if he does have time, if there's no imminency right there that it's going to happen on the spot, then he needs to bring that before me to review and to issue a warrant. Those two warrants both have a 48-hour lasting period. During that 48-hour time period, then, there has to be an evaluation for an order of protective custody, which is step 2, and you see that up on the screen. Now, the order of protective custody will then allow for somebody to be detained for up to 72 hours. Now, in order to get to an order of protective custody, what you're going to need is you're going to need a certificate of medical examination. Those of you that have worked in this field for a while have probably gone through this process. Again, this is the step where we say, okay, we've got a person that's in need of help. Maybe they're a risk to themselves or others on the spot. We're going to allow for detention for up to 48 hours. But in that 48 hours, you need a doctor to evaluate and to give support for that detention for it to continue for an additional 72 hours before we get to the probable cause hearing. And that's that OPC step that you see up there, order of protective custody. That's where, again, there must be some evidence that the patient presents a substantial risk of harm to himself or to others. If that doesn't exist, and this sometimes is a frustrating situation, if that doesn't exist, family members often say, well, how come you can't detain this person? They obviously have a mental illness. They obviously are in a situation where they're having some difficulty. How come you can't detain them and take them to go get some help? Well, if they're not a risk to themselves or to others, a substantial risk to themselves or others, then we have no basis under the law to help them at that point or to detain them. And you should actually feel good about that in this sense. Government should not have the ability to overreach and begin to take away liberties. Now, we're talking about, as a judge, let me just tell you, we're talking about taking away somebody's liberty against their will. I take that very serious. So if we're gonna do that, there better be an imminency, there better be a substantial risk of harm to self or others. Otherwise, there are other avenues that we probably need to pursue other than an order against that person's will. Now, after 72 hours after an order of protective custody, you're going to get to the probable cause hearing, and that's based on evidence, again, that there is probable cause to believe that the patient on an OPC presents a substantial risk of harm to himself or others. In the first cause, the EDW, the warrant, there was only a reasonable cause. That's all the law requires, reasonable cause. Now it's probable cause. That probable cause, though, is to hold them for up to 14 days so that we can get to a hearing on whether or not they actually are going to be detained for temporary inpatient mental health services. The point of a probable cause hearing is to determine, look, we've got an individual that's having a difficulty here. There is an application on file for detention for inpatient mental health services. Do we need to keep them in a controlled environment until we actually have that final determination? That's one of the responsibilities I have as a judge, is to determine, should I let this person go back home until we can have that hearing, or should we keep them detained until we can actually have that hearing? And that hearing is important because at that hearing then we have to have a second certificate of medical examination, that temporary commitment hearing. This is where the standards begin to significantly increase in favor of the patient, so that the patient, again, cannot be held against their will. At that temporary commitment hearing, which has got to be held within 14 days of issuing that probable cause hearing, I have to find, again, either that the patient is likely to cause serious harm to himself or others, or is suffering severe and abnormal mental, emotional, or physical distress, and I can only authorize detention for up to 45 days. That just changed. It used to be 90 days, now it's 45 days, unless I find specifically that 90 days is warranted. It's important when we move to the temporary commitment hearing to understand also that there is a significant shift in the burden of proof by the county's attorney. And he's going to talk probably a little bit about this when we go into the question and answer session. But I have to find, in this instance, by clear and convincing evidence. So if you're not a legal scholar, you probably don't know what clear and convincing evidence means. But in a regular civil case, there's a preponderance of the evidence, whether or not something's more likely or not to happen. Does it weigh a little bit in favor or weigh a little bit against? In a criminal sense, it's beyond all reasonable doubt, right? That's a very high standard. Clear and convincing evidence is right about somewhere in between there. It's more than a preponderance of the evidence, not whether or not I lean a little bit more in favor of one side or the other, but I have to have substantial evidence that this person indeed is in a situation where they need to be detained for a period of up to 90 days. The other interesting aspect about this period of time and this hearing here, which is different from the prior hearings that I've talked about, or the prior detentions, is you may get to this point and I may be able to find that the detention is warranted even if there is no serious risk of harm to themselves or to others. I can also find that they cannot provide for their basic needs because of this mental illness. So at this stage, once we've given lots of notice, once we have two doctors that are going to present a certificate of medical examination document to the court, whereas we're going to have a live hearing where the patient actually has represented counsel, which is Mr. Pattison here in Smith County. Once we have all these protections in place, now there's not necessarily a need for me to find that there's a substantial risk of harm to themselves or others. I can also determine that there is an abnormal mental, emotional, or physical distress, and that is causing them to not be able to provide for their basic needs, which provides the right to hold that person for a temporary commitment. Again, that only lasts for up to 90 days. Within that 90 days, then you have to come back and have an extended commitment hearing. That's for good up for an entire year. In order to have an extended commitment hearing, you have to already be in a temporary commitment state. So we can't just jump to that 1 year commitment. We can't get there. We've got to work through it sequentially. Again, this is really important to me. I cannot emphasize this enough. We'll talk about this here in a minute, but as the judge that's overseeing these cases, it's important to me that we look at each individual and realize I'm about to take the liberties of this person away from them involuntarily. Is this really what is best for the patient, and is this really what the law allows me to do. Cannot do this flippantly. I cannot do this flippantly at all. So we want to work through the process in such a way that their due process rights are protected, that they have the ability to be represented by counsel, that they have the ability to ask for a jury trial at the appropriate stages, which is not at every stage, but it is at certain stages. When we get to the temporary commitment hearing, a jury trial is not part of the process unless they specifically request it. When we get to the extended commitment stage, the jury trial occurs unless the patient specifically waives that right. So as you can tell, as I mentioned, as we move along the process and the potential period of time for detention gets longer, the protections get greater. The burdens get greater on the state and on the applicant to make sure that the patient's rights are protected. That's really what we're here for. Even though I'm not a medical doctor and I don't claim to be, I never played one on TV. I look at the individuals that come before my court as individuals who are really in serious need a lot of times of mental health help. And how am I as a judge supposed to play my role appropriately in that process according to the law? Now, the last thing you see on the screen is a renewal of extended commitment after 1 year. Got to come back. We've got to make sure that the extended commitment is appropriate and needs to continue for another year beyond that. And to see if that patient has improved. Again, that all requires medical testimony, requires support, requires advocacy on behalf of the patient by appointed counsel who is paid by the county to make sure that their rights are preserved. All of that process exists to do the best that we can for that particular patient. It is a complicated process. What I'm showing you up here is a very short synopsis of what occurs most likely in my court. The other thing you see up here throughout, it's in yellow, application for psychoactive medication. So we put this in yellow as well so that you could see that along with some of these hearings, when we get to the temporary commitment, extended commitment, and renewal of extended commitment, there is an opportunity, if I grant that, for me also to say to medical personnel, you have the right to administer this psychoactive medication even against the will of the patient, because we know it's best for them and they cannot make this choice for themselves. There's, again, a substantial burden that the state has to show to get to that point, but that is possible. So that's a general overview of the process. I know listen, we could spend a whole semester in law school talking about this, so it's a lot to take in, but we wanted you to have the 20,000-foot view of how exactly does that process work. Now let's go to the next slide real quick. I want to show you just a little bit about the players that are here today. We can leave this slide up as we talk. I won't expand on this, but what you're really seeing here is those players that are involved in my process typically are represented up here. We've got the court-appointed attorney for patients down at the bottom, the district civil attorney, who is going to talk a little bit about his role here as well. I'm the constitutional county court judge here in Smith County. I oversee mental health, guardianship, and probate. That's my responsibility here in the county. We have the hospitals that are involved in the process, the Andrews Center as well, and then we have law enforcement who are typically our first line of those that interact with folks that are involved in a mental health situation where they need some assistance. Those are the players. That's the process generally. I'm going to stick around afterwards to answer any questions you might have. Let me just say this up front. I'll apologize if I cannot answer you specifically about a fact scenario. It's actually against the law for me to do that. So though I appreciate the fact that sometimes you have these fact scenarios where you want to say, hey, my brother-in-law, this is what's going on with him, and what should I do, or how can I do that? That's actually where the law draws a line for a judge and says, you can't hear that and you can't talk about that, because that would then disqualify me from actually ruling on that if it came before me. So let me just apologize up front if I can't answer those questions for you. But otherwise, if you want to talk about the process generally, I'd be glad to do so. Appreciate what you guys are doing here today. Appreciate what you do day to day. Keep up the great work. I'm going to turn it back over to Mr. McSwain.
Thanks. Okay. The start of the process is generally with David Biggs. So I want him to come up and explain what type of situations you face and what you do. So that they know.
My name's David Biggs. I work for the Sheriff's Department. I'm a crisis intervention officer. Usually the first thing that happens, we get a phone call that somebody's family member's having issues, throwing things at the house, argumentative, fighting. We get called out and they tell us they're not on their medication or their medication isn't working. We get to go out and determine if, number one, is that person a danger to themselves or others? Is it due to lack of medication? And you just have to sift through everything, usually rather quickly. You have to talk to the family, find out what all is going on. Then you have to make a determination if you're going to take them to the hospital and if they meet criteria like the judge was talking about. Then you figure out if you need to take them to a hospital, which hospital will be best, and how do you determine what you need to do for their benefit. Parents don't understand, family members don't understand if I tell them I can't do it because they don't meet certain criteria, but I carry enough information in my Tahoe that I can give them other avenues and follow up with them. If they go to the hospital, we have to get them in the vehicles, take them to the hospital, and fill out what they call an EDW or a POW, which is emergency detention warrant or a peace officer's warrant for a mental health evaluation. That lasts for 48 hours. ER nurses and everybody else in the ER love you when you come in because you know we're fixing to take up a space and we're going to be there for a while. On average, it takes anywhere from 4 to 12 hours if you're lucky. If not, it can last for days. If you can't find a bed and they need a bed, it could last anywhere up to, we've sat on somebody for 5 days, and that's an officer off the street. That's why we're fortunate to have the CIT program because we get to sit in the hospital with them. If we're lucky and they're not combative, the charge nurses will let us leave, but usually we get to stay with them. The one thing I want you to realize is that we want what's in their best interest. They think we come in and we just beat up somebody, throw them in a car, and go off to either the jail or to the hospital. That's not what we're trying to do. We're trying to do what's in their best interest. If they don't need to go to jail, we try and defer them from there because it's really cost a lot more money to put somebody with a mental health issue in a jail. I would rather take them to the hospital and let them get help that way. It's just, you go in there, you take their blood, you take their urine, you see if they're medically cleared. If they have insurance, they usually talk doctor to doctor at the ER. If not, then you have to get the Andrews Center to come out, or a mental health authority, and get them to talk to the people and see if they can find somewhere to place them. The biggest way I explain this is that it's a slow process. Nothing's going to happen fast, and it's not going to go as quick or the way you want it to every time. You just have to make people understand that you're trying to do the best you can with the material that you have. After you do that, then you follow up, or at least I do.
Make sure and tell them how many calls you get a week.
Yeah, they average from week to week. This past weekend, I've dealt with 6 peace officers' warrants, and that's a slow weekend. One night I went to work, I work 1 to 1. I work 1 p.m. to 1 a.m. in the morning. I got called 2 hours before I was supposed to be at work and told me I had 4 in the ER at ETMC just to start my shift. And I'm thinking, oh, fun. I know where I'm going to be all afternoon. But it doesn't bother me because it put 4 deputies back out on the street. I rotate from room to room. Lucky enough, I know the ER nurses. I'm fortunate enough that I can talk to them. And most of them have sitters, so you can kind of rotate around to the one that's being the most obnoxious or out of control. Sit with them, talk to them. The main thing you want to do is see it through their eyes. What I see and what's normal to me is not what they see and what's not normal to them. Try and see it through their eyes of how they look at their lives and how they can figure out how to help themselves. I can lead them to the water, but I can't make them drink it. So the main thing I want to tell you is that it's a slow process. The more information you give me when I show up on a scene or any officer, the better, the smallest details can make the biggest difference. And I'll stay around if anybody has questions besides the ones we have up here.
All right, let me go to, I want to go to the next player in the process, and that's the Assistant District Attorney, Thomas Wilson. He's the one that has to make a decision, so I'll let you tell your situation and how you are involved in the process.
From the beginning, whenever we get a report or an order of protective custody or an application from the hospital, my office and myself, I evaluate it, I look at the facts, look at the evidence that we have presented through the physician certificate, and look and see, okay, does this person meet the criteria? Is the person a danger to themselves or others, a substantial danger to themselves or others? And do they meet all the technicalities that we have to have? Is there a mental illness in place? And a mental illness is specifically defined in the Health and Safety Code as schizophrenia, bipolar disorder, and other not otherwise specified mental illnesses. So your depression, your psychotic breaks, situations like that. That can be the most frustrating part, and I want to let you know, because I see a lot of nurses, nursing students, probably a lot of social workers out here. That information needs to be relayed in that application. The more information I can have in that application, the easier it is for me to go to the judge and say, Judge, we need you to sign this. And I know that, there are probably doctors in here as well, but I know for the most part that the social workers and the nurses fill out those applications. So, it's really imperative that that information gets passed along in that physician certificate. And then, did you want me to go on further on the process, or?
No, let's go next to Richard on it, and then we'll come back with questions.
Usually I'm called, is this on or?
I
Okay.
don't think you're on news by.
Usually when I'm involved, there's an application for temporary commitment already in place. There's got to be at least one physician certificate already there. And typically there's a probable cause hearing, and that's why I'm being called. And so I have access to medical records. They provide me all the medical records. I review all that first. Make contact with the patient. Sometimes I'm able to do that on the phone before we meet in person, and sometimes it's resolved that way. Sometimes I meet them in person at the courthouse. I always immediately ask their permission to involve their family. If they'll give me that permission, I always involve the family. I understand all the privacy issues, and I know that the treatment is going to be successful or not if everybody's involved. And 99.8 times out of 100, they'll let me contact family or significant others, and that's always good because they don't know me. And many times they still have trust in some family members. And so I involve them in the process. And a lot of times I'm able to just help them understand the process and take away anxiety and then encourage them to get the help that they need. I can't, even if I think they need the help, if they don't want the help, I have to advocate not for services. But most people just want education. They want to understand it. They want to understand what's available. They want to understand how they can get the help and also get out. They don't want to go in for a long time, and they want to understand the process so that they don't want the anxiety of it. At least that's what I find. And the most difficult thing is the first episode, psychotic, he was talking about earlier today. He called it first episode psychosis program. Boy, that's the most difficult thing for me. When I have a young person who's having what I call initial onset psychotic experience they've never had before, they don't really know what it is, and if they do know what it is, there's the stigma. They don't want it. And if they've been having symptoms and they haven't felt comfortable getting help, they're self-medicating. And so they mask the symptoms by taking drugs that have become socially acceptable. And that complicates it because they don't want to recognize that they're really treating mental illness with illegal substances. And that's sometimes difficult to get them to see. Sometimes they're willing to talk about it, and sometimes they're not willing to talk about it. But then you really have an educational hoop, and then it's imperative that the family get involved. There's lots of resources if people will allow you to connect everybody in the process. There's a lot of privacy issues, and so you have to be very careful by doing that. But most people will let you. And so many cases are resolved at the probable cause issue. You encourage them to get the help. They're willing to get the help. They don't really want to be part of a court process. They really want to be part of a mental health solution. And so I try very hard to go down that road and just put them in touch with the resources that are available. And I don't see them after that because they are successfully connected and they do go through that. Or unfortunately, because the situation, the legal part is crisis oriented, the crisis is over and the court's not part of it anymore. And so I don't always know whether or not they had a successful resolution or not. But they had the crisis was over and it didn't go through the court system. It just went through the hospital. So I don't always know, but you try to be part of the solution if you can.
What I'd love for you two guys, since y'all work together on it, tell us how you work together to get the best results
Right.
you can.
And so, from my standpoint, and if you ever go to law school, the first thing they teach you is we have an adversarial system. Our system pits one party against another. And this mental health system that we have, it's not conducive for an adversarial system, but like the judge said earlier, it's the system that we have and it's the bounds that we have to follow. So a lot of the process that we have, that Richard and I play, is in the beginning, in that probable cause stage, because Richard's been doing this for 30 years. I've been doing it for about 5. So he sees the people, and we'll come in and we'll talk and we'll say, hey, this person, this is going to be one that's going to be a long, drawn-out process, and we'll say, okay, this is a person that's going to be here for, a week and a half. They're going to be in the hospital. We're going to do a probable cause, and we'll do an agreed probable cause sometimes. And they'll go to the hospital for a week, 2 weeks, get on their meds, and be stabilized and move on down the road. But we work together to come up to a solution if we can. Sometimes we just can't, and that's when we move forward with the court process and we have the hearings necessary and go that route. So
I would say we have a very good working relationship. I don't go to him with cases that I don't think there's more to it. If I've met with the family and I've met with the patient and I think there's more he needs to consider, I know that he will consider that. And I know he'll talk to the family members if I need him to do that, to find the best solution. Sometimes the paperwork will look one way, but the reality is somewhat different. And you don't really know that until you meet the patient, you dialogue with the patient, you talk with the family, and you realize, I don't think this is exactly what happened. It may have been good to start the process with, but things aren't really that way. And so from that standpoint, I'm glad we have a good working relationship together. We don't always see it the same way. And of course, he's got to worry about the criminality and the safety of other people. And he has other concerns other than just the patient. But I'd say it's a good working relationship. It's a trusting relationship. Sometimes there are situations where I have a client that's unable to communicate. Sometimes I have a client that has dementia and mental illness. And when that happens, we have to have a high level of trust, because if I allow my client to receive treatment and then they come out of whatever it is and they want more due process, we pretty much have an agreement that he'll allow it. In other words, if I give up some rights because I want to do the right thing for them, and then later they get well and they want to participate more in the process, then I want them to have that right. And I know that he will allow that, and that's important.
And I do know that I believe this conference is focused a little bit more on the the younger age, but dementia is a tough situation in our mental health system because we do not have a legal mechanism in the section of the Health and Safety Code that we deal with specifically here to deal with dementia. In fact, it says that dementia is not a mental illness for the purposes of the mental health court. So we really have to wordsmith our way around some of that, the physician certificate, and make sure that the hospital understands that we want to work with y'all. And I understand there are actually cases that have come in through the court that I've had to say, we can't do this. There's no way for us to fall within that the statutory guidelines because of the dementia is the pure reason for the commitment. And so it's hard to tell doctors, it's hard to tell staff, it's hard to tell family that we can't do anything. There are other avenues that you're going to have to take, but that's something that I wrestle with a lot because I understand that this person with dementia can't go out and function on their own. They can't function independently, but in the same time, my job, first and foremost, as an assistant DA, is to seek justice. That is the number one thing that a prosecutor is supposed to do, is to seek justice. So if it's not within the statutory framework, then it's outside of justice, and I cannot do that. So that's the problem. That's one of the things that I wrestle with a lot.
Thank y'all. So, Judge Moran, I want to turn your attention to the other criminal side of the docket. I have a question about a mental health court and what the status is of jail diversion in Smith County.
That's a great question, and I'm happy to address it today because we actually, this fiscal year, appropriated money and received a grant from the state, for part of it, and then appropriated money from the county budget for the other part to start a misdemeanor mental health program in Smith County. And Thomas is working very diligently to get that going. In fact, by the end of this month, we anticipate that will be in full-blown ready status. And that's very exciting because what that's going to do is for those that have a misdemeanor criminal charge as part of their probation, they can be sent to Judge Ellis's court, County Court at Law, and Judge Ellis then will meet with them on a periodic basis, as will a specialized team of probation officers and the district attorney's office and my mental health coordinator, Donna, who's here today as well, to make sure that those folks, as part of their probation, get the mental health treatment that they need. And a lot of times that black robe effect is all that they need in their lives to help them continue to stay on their medications when they know they're going to have to report every week or every other week or once a month to the court and say, yes, I promise I'm staying on my medications, I'm doing what I'm supposed to be doing, I'm receiving the treatment I'm supposed to be receiving. Those things are vital to continue to help keep those folks out of our jail system, which is not where they belong, but somewhere where they can get outpatient treatment. So we're excited about that.
And by the way, it has a 74% success rate in keeping them on their medications and helping them live productive lives. So I'm going to turn this question and Ron, you might have something to say on this one, but what do you do, what can a family do if, for instance, the loved one, it's clear they have a mental illness, but they don't present a substantial risk of harm to themselves or others, and they haven't used the suicide word or haven't done that. Just some of you, and David, you may comment on this. What can you do? What can that family do?
The first thing you're going to have to do is talk somebody into being able to recognize they even have an issue. Half the problem is going to be them admitting there's an issue. The thing I want to do is I talk to them and I want them to be a part of their own solution. I try and sell it to them like I've told everybody before, like a used car. I want them to buy into it. Because if they can't realize that they have an issue or don't feel like they have input, then they're not going to do it as well. If you try and make them realize that they need to have a vested interest, then that would be the best. Plus, you can give them a bunch of different choices, and the more options they have, the more power they have, because they can figure out which one they want to go do.
I want to comment on that. Any of the others?
I just want to make one comment. Some proposed patients are worried about medications, certain medications, and it's a two-step process. You cannot have medication against your will until you're under a commitment, and even then, you have a right to have a separate hearing on the medication issue. And I don't think they realize that. I don't think they also realize they have a right to meet with their treatment team and discuss their medications, and that they'll listen to them. And sometimes in the process of the probable cause hearing, sometimes we'll have a doctor there, and I'll just question the doctor. And I'm really doing this for my client's benefit, and asking the doctor about the medication process and the treatment team, and letting the patient hear that they're going to have input. Because sometimes a patient knows they've reacted poorly to a medication, they're afraid of it, but they've responded well to other medications, and they want to be part of the process. They are not presumed incapacitated. They are not presumed incompetent because they're mentally ill. They have all those presumptions of capacity and competence. And I assure them that they do, and that they can participate in that, and that the doctors and the staff will listen to them if they will do that. Okay. And usually that melts away some of the resistance.
And I think Richard, this one.
This one.
I think Richard touched on something very important, and that is the family key, the family dynamic. So many times in our court, people come in and they don't have family there to not testify against them, but to be there to support them. And the ones that are successful are the ones with somebody there that can pick up where the court can't pick up or where the hospital can't pick up. And I will tell you this, if you come to our court and you're a family member and you're concerned about having to testify against that person because you're their only support network, I, in my role, will not call you to testify. No matter how important your evidence that you're going to present is, I will not call you to testify because I know that if you burn that last bridge, that person is going to be on a downward spiral that they're not going to be able to come back from. So know that if anyone that you know or you yourself are involved in this or a family member is involved, that we're not going to put family in a position to, if they don't want to burn that patient and to testify against them. So
That's so important. Trust me, I know. Ron, could you comment a little bit of what can families do if they've got a loved one, but they don't have substantial risk of harm to themselves or others? What can they do?
It's a tough situation, and it's a very common situation, particularly because sometimes when people are, very symptomatic, their insight into what is going on and their willingness to acknowledge or see their need for help is impaired. I mean, there's actually been studies that suggest that the part of the brain that we use to formulate insight may be impacted. And there's no easy answers, but I sort of thought of 4 things, and I'm thinking more globally here, not necessarily specific to the code here locally or procedures, but there are some jurisdictions that have broader criteria than just dangerous to self or others. They might include gravely disabled, so inability to care for oneself, even if it doesn't quite meet that threshold of dangerousness. There's even a couple, there's a state I'm aware of that has a need for treatment standard, which is very broad and which has been actually been challenged constitutionally. But the problem is oftentimes also sort of a reluctance to really utilize the commitment code because of lack of beds, which is a big problem. So I thought what you said about trying to help the person sort of get to the point where they acknowledge their need for help is important. And even if you can't get the person to acknowledge that they need medications, sometimes there's certain things that are important to the person that might be at risk if they don't get help, like housing, for example. They might lose their housing. that at times can be, and I know this all sounds very draconian and coercive, but you try to work with the person and help the person understand without engaging in an argument with them about whether they're mentally ill or not. Peer specialists, I don't know if you have those here, but people who've walked the walk can really help others sometimes understand, whereas the best psychiatrist in the world or most persuasive police officer or judge can't. And then finally, this is a little bit more upstream, but if in some states authorize psychiatric advance directives, and people can, when they're well, say what their preferences are, and even designate somebody who they authorize to be their surrogate decision maker, should they lose the capacity to make an informed treatment decision. So those are all, options, but there are no easy answers in those kind of situations.
One question that came up that I'd like to speak to is HIPAA and HIPAA authorizations. What do you do when your loved one is above 18 years old and won't give the physicians authorization to speak to you? It's an incredible problem, and as Ron mentioned, many of the healthcare providers don't understand HIPAA. They just think, well, I just can't risk talking to them. So here's what I did with our son. When he wouldn't give me a HIPAA authorization, I'd go to his doctors and I'd say, hey, suppose somebody's manifesting this symptom and this symptom and this symptom, just hypothetically. What do you think could be wrong with that person? And they usually respond to that because it's not directly asking about his diagnosis. So I'll give you that idea, and sometimes it works, sometimes it doesn't. But I guess we're done on time, or do we have more? We're done. We're done. Thanks to everybody.
Let's give all of our speakers, our presenters, a great round of applause. This event is not possible without wonderful sponsors. Once again, let's give our sponsors a great round of applause. And thank you to Samaritan Counseling Center of East Texas.